A judge catches cops lying on the stand and throws out the main evidence in a case. You want to hear more, right? Well, let's get to it. My name is Jamahl C and I'm a criminal defense attorney in San Diego, California. And in this video, I'm discussing a case out of West Virginia in which a judge ultimately granted a motion to suppress evidence. On June 6, 2020, David Lee Bumgarner was arrested for being a felon in possession of a firearm. If you didn't already know, if you've been convicted of a felony, you lose your right to possess firearms. So if the police catch you with a firearm and you've been convicted of a felony, this would result in criminal charges. So Mr. Bumgarner was arrested and eventually charged with one count of felon in possession of a firearm. His lawyer filed a motion to suppress evidence. A motion is simply a request for the judge to do something. In this case, the defense attorney was asking the judge to suppress the evidence in this case, specifically a 9mm pistol and magazine, crime lab analysis from the DNA taken from the handgun, and the pictures taken of his truck and the pistol. The court held a hearing to determine whether the defense motion would be granted. Patrolman Michael Hall and Trooper Zachary Holden testified at the hearing. What happens as part of the procedure for motions to suppress is the defense attorney files the motion. The prosecutor then files an opposition seeking to justify the search and seizure, and then the court holds a hearing in which the officers testify as to what happened. The attorneys then make their legal arguments for and against suppression. So Bumgarner was driving a Chevy S10 he borrowed from a neighbor. He had a female passenger riding along with him. Patrolman Hall said he saw the S10 coming from the opposite direction as he drove down the road. The driver did not have a seatbelt on. As a side note, not wearing a seatbelt while insanely dangerous is an easy way to set yourself up to be pulled over by police. And also, it's a good idea to make sure all your lights are in working order to avoid being pulled over. So Hall activated his emergency lights and made a U-turn to make the traffic stop. Hall gave conflicting testimony regarding the amount of time he followed Bumgarner. First, he said it was 30 seconds to a minute, then it was 20 seconds, then back to 30 seconds to a minute, and he finally landed on 1 minute. Bumgarner pulled into a parking lot. There was no evasion or a failure to stop within a reasonable time. Hall interacts with Bumgarner and the female passenger for about 2 minutes without incident. Hall never asked about a gun. He didn't see anything suggesting criminal activity. He goes back to his vehicle to run their info. He did not find them to be any safety risk. Trooper Holden then arrives a few minutes later. Holden said he spoke to Hall about what happened, but Hall denied any such conversation took place. Holden claimed familiarity with Bumgarner based on secondhand information. Holden ordered Bumgarner out of the vehicle. Now this is interesting because again, Hall felt that Bumgarner posed no threat. Holden conducted a pat-down search, finding no weapons. He handcuffed Bumgarner and sat him in the back of his patrol vehicle. Holden ordered the passenger out of the vehicle as well. He said he saw a gun in plain view under the front passenger seat. Now getting to the legal issue here, the Fourth Amendment protects us against unreasonable searches and seizures. A search without a warrant is presumptively unreasonable and a violation of the Fourth Amendment. Evidence obtained from an unreasonable search is inadmissible in court unless there's an applicable exception. Without one of these exceptions, evidence must be suppressed or thrown out under the exclusionary rule. Side note, one of these exceptions is consent. Police cannot search your house, your vehicle, or your person without a warrant. But if you give them consent, they no longer need a warrant. So do not give police consent to search unless you like giving up your constitutional rights. The police in this case did not have a warrant, yet they searched the truck and seized the handgun. So the main issue in this case was whether the plain view doctrine would justify the warrantless search and seizure. Trooper Holden testified that when he saw the gun, he was standing upright outside the passenger side door, not bending down or into the truck. However, the judge said after viewing the images, this line of vision did not appear possible. In other words, he lied. The photographs showed that the gun was completely under the passenger seat. and the color of the gun blended with the seat and the carpet, so there's no possible way he could have seen the gun from where he was standing. The judge found no justification for the search whatsoever because the only crime being legitimately investigated was Bumgardner not wearing a seatbelt. She went on to say, Trooper Holden failed to develop probable cause that the pickup contained any contraband items or that the defendant and his passenger were presently engaged in any illegal activity before entering the pickup truck. Patrolman Hall's testimony contradicted some of the central points of Trooper Holden's testimony, was internally inconsistent at times, and he answered that he did not recall in response to questions at least 14 times. Aside from how often he couldn't remember important details, Hall claimed to remember certain events with exact specificity while failing to remember other events in the same time frame altogether. As a result, the court found the credibility of the evidence presented, including whether the weapon could be seen from Trooper Holden's purported vantage point, to be questionable at best. At the end of the day, this is a very fancy and eloquent way to say, I don't believe you. Had the gun been visible, it still would not have been proof of a crime because it's not illegal to drive with a gun in West Virginia. Neither officer had direct knowledge that Bumgardner was a felon. As a result, the search was found to violate the Fourth Amendment protection against unreasonable searches, and the evidence against Bumgardner was thrown out. While I hate to hear stories about cops bending the law and violating people's rights, it's great to see judges doing the right thing and granting these motions. This also goes to show the importance of having a solid defense attorney who will go through the details of your case with you and challenge the government when they're out of line. Well, I hope you enjoyed this video. If you did, please show me some love and hit the like button. If you haven't already, please subscribe to my channel and make sure you turn on notifications so you never miss a new video when it drops. As always, I want to thank you so much for watching. Until next time, peace.